Yes.
Good morning, my lords. In this matter, I appear with Mr. Blake for the Respondent, Sinovac Biotech Ltd. And my learned friends, Mr. Chivers KC and Mr. Parsons, appear for the Appellant, 1Globe Capital LLC. I understand, my lords, indicated that we'd like to hear from me first on the question of whether permission to appeal should be granted in respect of grounds 1 and 3.
Yes, I perhaps should explain to those who have come to listen to the case that the board has requested the parties to start the appeal by addressing the question of whether the appellant should be given permission to appeal on certain grounds that were not argued in the courts below.
Lord, yes. Those grounds concern two matters, the rights agreement and discretion. The most significant of these is the rights agreement. This occupies the vast bulk of 1Globe's written case, specifically the new proposed breach of fiduciary duty arguments, which were not run, as you say, my lord, either at trial or before the Court of Appeal. They were first raised in 1Globe's second amended application for permission to appeal to this board, and we say that there are no exceptional circumstances such as would justify the grant of permission. I will first provide a very brief outline of our position, identifying the new case for which 1Globe seeks permission and why we say that such permission should be refused. I will then set out the test to be applied in determining whether to grant permission, and I will finish with the application of that test to the present circumstances. So first, by way of outline, by ground 1F of its amended grounds of appeal, 1Globe asserts that the Court of Appeal should have found that the rights agreement was adopted by the directors in bad faith. We say it is trite law that any allegation of bad faith must be squarely alleged and squarely put to witnesses. No such allegations were ever made at trial, as both the judge and the Court of Appeal found in clear terms in their judgments. Whilst there was witness evidence at trial and cross-examination, and indeed the factual inquiry as a whole, that was directed to issues surrounding the AGM. The only argument that 1Globe ran at trial on the validity of the adoption of the agreement was a short legal point, which was not dependent upon any factual inquiry. We say a new allegation of bad faith at this stage is clearly impermissible on a second appeal. The second allegation that 1Globe seeks to advance is that the rights agreement was entered into by the directors for an improper purpose. Again, even applying the approach of the English cases on which 1Globe now wishes to rely, such an allegation requires a factual inquiry as to the subjective intention of the directors. That was no part of the trial, and the material is simply not there for you fairly to do so now. We also say that directors of an IBCA corporation are not subject to a separate proper purpose fiduciary duty at all. And we say that as a result of 1Globe not taking this point until now, your lordships have been deprived of the opinion of the Antigua courts on this important question. 1Globe has two further proposed arguments. The first is that the adoption of the rights agreement affected the voting rights attaching to the common shares, and they say that therefore this required an amendment to the articles. The second is that the grant of options under the rights agreement could not be made by way of a dividend pursuant to section 52 of the IBCA. Whilst these two short points are not dependent upon a factual inquiry, they also do not meet the threshold of exceptional circumstances justifying leave to appeal. Neither represent an arguable point of law, and we say nor are they ones of general public importance which ought to be considered by the Judicial Committee. Given that they relate to a specific contract in a specific factual scenario, they are not of general public importance. And we also say that neither represents an arguable point of law. The first is plainly wrong. It fails to distinguish between a variation of rights attaching to shares and the enjoyment of those rights, a distinction well known to company lawyers. The allotment of further shares does not vary the rights attaching to existing shares. Of course, in fact, we're not dealing with an allotment per se, but the same point applies. An issue of options to subscribe for shares does not vary the rights attaching to existing shares. And we address this at paragraphs 43 to 48 of our written case. The second argument seeks to apply a gloss on section 52 of the IBCA, and again, as we set out in our written case at paragraphs 86 to 90, this ignores the plain language of that section. And in any event, the point goes nowhere. Even if this were not a distribution, there is a separate power to grant options in any event under section 35 of the IBCA. And finally, as to ground 3, discretion, this does not relate to the rights agreement, but to the AGM ground. There is no issue between the parties that in the event that 1Globe were successful on its main appeal on the AGM ground, it would not be shut out from making submissions as to the effect of that success on the overall exercise of the judge's discretion. However, 1Globe seeks to go further. It seeks to pursue a freestanding ground of appeal that the judge exceeded the ambit of his discretion under section 122 of the IBCA, and this is on the basis, it is said, that discretion is limited to the form of relief and not as to whether to grant relief at all. This is obviously wrong and hence not an arguable point for the reasons we explained at paragraphs 158 to 163 of our written case. It is clear from the plain and extremely wide language of section 122 itself, and it is also entirely inconsistent with the Canadian cases on that section, which emphasise the extremely broad width of discretion, and we have cited those cases. They are Cluac and Dumont. In Dumont, for example, in deciding not to grant relief, the very point here, the court held that in exercising its discretion, it could take into account matters including the essential fairness of the electoral process. And again, on this, we say, given the specific nature of this dispute, that this is not a point of general public importance. With that outline in place, I now move on to the test. We've addressed this in our written case at paragraphs 28 to 31, where we cite 3 cases: Primeo, Baker and Gruels. I won't take your lordships to all those authorities given time, but they stand, we say, for the following propositions. First, in the adversarial system, it is for the parties to identify the issues for determination at trial and to adduce evidence and cross-examination directed to the case that they are advancing, and they must advance their entire case. The other party is thereby able to know the case it has to meet and address that case and evidence accordingly, and the judge will determine only those issues. That is Primeo at paragraphs 148 and 149. Secondly, a new point may be taken on appeal for the first time only if both, firstly, the court is satisfied beyond doubt that it has before it all the facts bearing upon the new contention, as completely as would have been the case if the controversy had arisen at trial. And secondly, that no satisfactory explanation could have been offered by those whose conduct is impugned if the opportunity for explanation had been afforded them in the witness box. That is the Tasmania, again cited in Primeo 152. Thirdly, the Judicial Committee's practice is not to allow even a pure point of law to be raised for the first time before it. This is departed from only exceptionally where the proceedings below would not have been conducted differently if the point had been taken at first instance, Primeo paragraph 155. And more particularly, that point must be both incapable of depending upon an appreciation of matters of evidence or of facts of which judicial notice might be taken, and it must be one upon which the Judicial Committee would not derive assistance from learning the opinions of judges of the local courts upon it. That is Baker at page 788. And finally, where arguments are deployed late, the Judicial Committee is deprived of the considered conclusions of the court of the country in which the dispute arose, in circumstances where the new argument may have considerable implications for the law of that jurisdiction. Rules of 2425. I move on to the application of these tests. In doing so, one needs to consider the case that was run below. At the time the present proceedings were commenced, they were concerned solely with the conduct of the AGM. In its reply, 1Globe, for the first time, sought to challenge the validity of the adoption of the rights agreement. It accepted, in its skeleton for the Court of Appeal, that it bore the burden on this, paragraph 74 of that skeleton. A very small part of its written and oral submissions at trial were devoting to setting out its case on invalidity. In fact, the only point taken on invalidity was a short point of law on sections 161 and 163. That is the variation of rights argument that my learned friend seeks to deploy again now. Importantly, there was no allegation of bad faith, there was no allegation of improper purpose. The factual evidence was not directed to those issues, it was directed to the AGM. The only evidence from any director was a very short 9-paragraph affidavit from Mr. Anderson, one of the 3 independent special committee members. He devoted 6 lines to the rights agreement, simply referring to a press release. There was no cross-examination directed to those issues either. These new allegations of breach of duty were not put to Mr. Anderson, let alone to all the directors. And of course it follows that the directors were not afforded any opportunity to meet a case which had not been advanced, that of breach of duty. Indeed, there was no reference to directors' duties in the oral or written submissions. The cases on which 1Globe now seeks to rely, such as Howard Smith and Ampol, JKX and Hogg and Cramphorn, were not cited by either side. In his judgment, the trial judge held expressly that there was no allegation of bad faith or any suggestion that the agreement was entered into other than in accordance with the board's fiduciary duties, paragraph 51. The Court of Appeal similarly found that there was no pleaded allegation of malefides and that it was not a ground of appeal, and that there was no challenge to the judge's findings that there was no allegation of bad faith or suggestion of breach of duty, paragraph 98 of that judgment. In those circumstances, as regards the allegation of bad faith, first, as I've indicated, an allegation of bad faith is a very serious one to make against an individual, and such an allegation must be squarely alleged and squarely put to the witnesses. None of that happened here. It was not pleaded, it was not alleged, it was not put to a witness. Secondly, an allegation of bad faith inevitably requires an investigation of the subjective state of mind of the relevant individuals. There was no such investigation here whatsoever. So we say plainly, this meets none, let alone both, of the requirements under the Tasmania test. You cannot be satisfied beyond doubt that you have all the facts bearing on the new allegation as completely as it would have been the case as it arisen at trial, and nor can you be satisfied beyond doubt that no satisfactory explanation could have been offered by the directors, whose conduct is now sought to be impugned, if the opportunity had been afforded them at trial in the witness box. And it also goes without saying that the trial would have been conducted completely differently had such an allegation been made. Turning next to improper purpose, We say, as I said, that there is no proper purpose duty under Antigua law. But even if English law cases upon which 1Globe now seeks to rely were applied, such as Howard Smith and JKX, it is clear from those that any allegation of improper purpose is again necessarily dependent on a factual inquiry into the subjective state of mind of the directors. As was said in Hindle and Cotton, which was approved in both cases, I quote, "The state of mind of those who acted and the motive on which they acted are all important." Howard Smith involved a 28-day trial involving the cross-examination of all the directors who voted for the allotment. JKX similarly involved cross-examination of 6 of the 7 directors. The reference to the so-called constitutional divide in those 2 cases is not a separate ground for invalidating the exercise of a power without examining the subjective state of mind of the directors. Indeed, had that been the case, there would not have been the need for the extensive cross-examination that took place. It is simply a part of the proper purpose inquiry. Furthermore, because the issue was not raised below, there has been no opinion expressed by the courts of Antigua, either at first instance or by the Court of Appeal, as to whether such a duty even exists under the law of Antigua. 1Globe has not referred to any authority from Antigua which addresses the question. And indeed, both the statutory provision itself and Burgess, the leading textbook on Caribbean company law, suggests that it does not. Antigua follows the Canadian model, and such a duty does not apply in Canada. This is clearly a point of potentially wide-ranging import for Antigua and indeed elsewhere in the Caribbean. And we say it certainly cannot be said that your lordships would not have benefited from the opinions of the local courts on such an important issue. And on top of that, even if either or both of these breach of duty allegations were runnable points, any claim for breach of duty would be statute barred. This is our case at paragraph 78 to 80. The relevant limitation period expired on the 15th of March 2022. My Lords, I've already dealt with my points on the remaining proposed arguments, which we say are neither arguable and nor do they raise points of general public importance. I therefore respectfully submit that your lordships should refuse permission to appeal. My Lords, those are my submissions.
Thank you very much.
Could I just ask one question, if I may? The 2 additional sort of narrow or purely legal grounds that the appellant seek to raise in respect of the rights agreement, can you just point us to where are they set out in the statement of facts and issues, for example? Or where do we see those points clearly stated?
We see, well, they're certainly addressed in our skeleton argument. I can give you those references, which I can.
Presumably they're addressed in Mr. Chillings's
yes.
case as well.
I'll see if we can find.
Thank you.
Which I don't
I'd
have
like to know where those are.
Would you like the reference from my learned friend's written case or from another?
The written case would be better.
Yes, it's 23 of my learned friend's written case. I think I gave your lordship my references.
You did, so you're right, you did do that. So it's paragraph 23, is it?
That's the first argument.
That's the first argument.
And 40...
23. Yes, I see.
I'm just checking the second. We think it's 51. 51, you say?
Maybe Mr. Chivers can help.
Dividend point. It starts at the dividends point is at 86.
86. Thank you very much.
And are those different from the small points taken on the rights agreement at first instance, or the same?
The variation of class rights point was taken. The dividends point was not.
So the one at paragraph 23 was taken below, is that right?
Yes.
I see. So we've really got one new point, have we? On
Correct.
Yes.
Dividend.
The one at 86.
Yes.
Yes. All right. Thank you.
And just to confirm, the first of those points, although taken below, was not swept up into the original permission to appeal.
No, it was rejected at trial, it was rejected at the Court of Appeal, and the Court of Appeal refused permission
I see.
on anything in relation to the rights agreement, so there was nothing.
And no application for special leave to the board after that?
Only at the second amendment, at this point only
Yes,
raised at
sure,
the second
okay.
amendment to their application
Yes.
for this board.
But not at the first two bites of the cherry?
I think not, my Lord, no.
Right. All right. Thank you.
Mr. Chivers.
Thank you, my Lord. The validity of the rights agreement came before the court only as a stepping stone to the company's alternative defence to the AGM round. And the judge, having determined the AGM issue against the applicant, didn't need to go on and decide the rights issue ground, but he did so because both parties agreed that a declaration would be of use for the benefit of proceedings before the Court of Chancery in Delaware. And at page 1021 of the bundle, you will see proceedings in the Delaware Chancery Court and this is an order denying request, that's Sinovac's request for trial date in September 2018. So this is before the trial had taken place at first instance. And the Vice-Chancellor refers to the Internal Affairs Doctrine. This matter raises important questions of Antiguan law. Sinovac Board muddled the waters by adopting a rights plan which recites it's governed by Delaware law. It's a head-scratcher. In my view, the Internal Affairs Doctrine raises serious questions whether the Board of Directors of an Antiguan corporation can adopt a rights plan and select Delaware law to govern its terms. And then he expresses his skepticism in paragraph 3. And at paragraph 7, you'll see that the company was asking for an expedited trial so that the Antigua court could have the Delaware court's opinion on whether the trigger had been operated. He says, to my mind, that's backwards. The Antigua court is far better situated to resolve this matter than this court. Important questions of law should be decided by the courts of the sovereign, whose law is at issue. At best, this court can opine on how Delaware law would govern if the choice of law clause in the rights plan selecting Delaware law actually holds up in the face of the Internal Affairs Doctrine. That ruling may not be of much help to the Antiguan court. It would be much more beneficial for this court to have the benefit of the Antigua court's views on the law of Antigua and Barbuda. So, the trial below proceeded accordingly, and that is why the declaration that's under appeal today was made. It was made purely as a stepping stone for the Delaware court to hear what was the law of Antigua. Following the judgment, the matter went back to the Delaware court, and you'll see that at bundle page 3127 to 3129. Where at 3127 line 4, the Vice-Chancellor said, a rights plan is a control device that functionally operates under the Internal Affairs law. The Antiguan courts have recognised this, at least the trial court did, when it held under Antiguan law, the board had authority to deploy the rights plan.
And sorry, this document is what? That
This document is a further ruling of the Vice-Chancellor in the Delaware court. It came about when the applicant, the appellant, applied to the Delaware court for an injunction to restrain the board from implementing the rights agreement. And that injunction was granted pending further order. He refers to the fiduciary claims governed by Antigua law. Bizarre that a fiduciary could deploy a rights plan and select another state's law. And at 20, I felt the Antiguan court should be deciding this matter. I felt very strongly about the need to show deference. And then at 3128, what instead transpired, parties in Antigua said to the Antigua court, no, this issue should be litigated in Delaware. The Antiguan court, a deferential statement, agreed and said this court should be deciding the trigger issue. He then says he doesn't think he should be deciding that, but he's stuck with it. And at 3123, line 1, we have a dispute that we have to deal with. So the findings at 3131, he says, state of play, these findings have been made in Antigua, decisions happened, time come for me to forward to address the case in this jurisdiction. But that's still subject to this appeal. So what the Delaware court asked was to know what the law was of Antigua. Now, first of all, we say that we're entitled to leave as of right because we're over the monetary threshold. It concerns the dilution of the appellant as a shareholder of the company.
I don't think that you've asked the local courts for leave as of right, have you?
On this issue?
On this issue, I don't believe so.
Yeah.
Well, without the approval of the local courts, how can you assert that you have an appeal on this issue as of right before this board?
Well, my lord, I will move on to the discretionary leave. The point is arguable. We've set out in our written case. Indeed, it's compelling. We say that Stainer was wrong, and that is a clearly arguable point. The question is whether rights plans are permissible in common law jurisdictions is itself a point of general public importance. I should say when we talk about rights plans, we're talking about a rights plan as understood here. We're not talking about poison pills in general or allotments of shares for improper purposes generally. Secondly, the power of directors to threaten a shareholder with sanctions if they exercise their shareholders' rights contrary to the wishes of directors is itself a matter of general public importance. We say there is simply no such power. And the question of whether the proper purpose rule governs directors' duties in Antigua and other jurisdictions is clearly a point of general public importance. Now, it is said that we're seeking to raise a new point on appeal. That's not right. My learned friend referred, and great play, one understands why, on appeal ground 1F, which is the point at which the proposed grounds of appeal, and it's in the bundle at page 243, it's ground 1F. There is a ground of appeal based on bad faith. But primarily, when one starts at ground 1A, the rights agreement ground, there is no mention of bad faith, and this appeal does not turn on that. And I'm certainly prepared to proceed in this hearing on the basis that no allegation of bad faith is made. I don't need it, and I don't need to pursue it. And when that's got out of the way, you'll see that this isn't a new point at all. The point was first raised, as my learned friend has said, but I think we need to see it, in bundle at page 305, in an affidavit, which was in effect standing as the reply. There had been a statement of claim on the AGM ground, but subsequent pleadings took place by way of affidavit. Rather unsatisfactory, and it may be why some of these points haven't been teased out. So this affidavit is in reply to the affidavit in defence, which for the first time raised the point that the AGM vote hadn't passed because the rights agreement had already triggered.
Which paragraph's this?
So if at 305 we look at paragraph 14.
So paragraph 7 of the defence is where the rights agreement was pleaded or raised.
Yes.
Is the defence also an affidavit?
So, yes, the defence is an affidavit. So, Guangyang 3, this document is the defence, starting at page 300. That's the defence.
Oh, that's the defence.
Oh, I thought you told us this was the reply.
I'm so sorry. That was the defence.
Not a reply.
And that introduced the poison pill, and it was first pleaded at paragraph 14. The second part of the paragraph, company believes shareholding will be found to have been diluted pursuant to the operation of a rights agreement applicable to the company, currently the subject of litigation proceedings in Delaware. That is then replied to, so the affidavit replying to that is in effect the reply, and at 316, paragraph 25, the rights agreement was not validly adopted under Antiguan law because Antigua, which applies English common law, does not allow defensive shareholder rights, absent stockholder consent. And or two, separate point, it wasn't validly adopted under applicable Antiguan law. That's the section 161 rights point. So the common law question, can you enter into these at all, was clearly raised by way of reply. Then...
well, on two specific grounds.
On two specific grounds, yes. And then at 27, under English common law, I understand the shareholder rights plans are impermissible defensive measures. And the reference there is to criterion properties. Now, the House of Lords reference there...
This is paragraph?
Paragraph 27.
27.
But criterion, insofar as it deals with poison pills, is dealing with those on a proper purpose basis. It's a summary case. It deals with it on a summary basis, saying this type of agreement cannot be entered into. It's beyond the scope of the director's power. There was no inquiry that needed to be made in criterion. That was dealt with summarily. And so here we say you can deal with summarily this issue. Since, and at 28, since then, our understanding its common law prohibition has been codified by statute. Now, we're not pursuing that question, but the common law validity of the rights agreement was clearly run and was clearly raised. And then in answer to that, although there was no further pleading as such, we then go to 334, which is Guangyang 4, and at page 334, paragraph 14, the rights agreement is mentioned. The purpose of the rights agreement was and is to guard against partial tender offers, open market accumulations, and other abusive or coercive tactics. So here's the company's evidence. The common law right to do this has been challenged. Criterion is referred to, but this is a quasi-pleading. It's half an affidavit. I believe that. There's no request for particulars as to the common law base. That's simply what is said. Then the evidence comes in, and the evidence is this is the purpose for which the company entered into the rights agreement. That's repeated by the director, Mr. Anderson, at 358, paragraph 6. Where he says, 358 at paragraph 6. Mr. Anderson gives evidence. As can be seen from the press release, the rights agreement was designed to ensure all the company's shareholders receive fair and equal treatment in any event, any proposed takeover of the company, etc. Then, in reply to that evidence, the appellant asserts, page 373, 374 to 375, 374 at the bottom, paragraph 7, 1Globe believes the respondent wrongfully deployed the rights agreement to unfairly safeguard management consortium to acquire the respondent at a price below the market value, rather than to guard against tactics to gain control of the respondent without paying all shareholders a controlled premium. So that's fairly raised in evidence. The Delaware position is contested by Mr. Walsh at 390. This is the company's, this is the appellant's expert, 390, paragraph 9. Upon information and belief.
Well, paragraph 7 is about the deployment of the rights agreement. Is it about the making of it?
It hadn't at that stage been deployed, if I can put it that way, save insofar as it had been pleaded that it had automatically triggered. The board hadn't actually done anything at that point beyond enter into the rights agreement.
Well, except that the board had by then said the effect of the rights agreement was to achieve a dilution which kiboshed the dissenters at the AGM.
Yes, so that's what they said. Yes. But again, this is evidence by this point.
And I'm sorry, which was your next paragraph?
Yes, the next one is at 390. The expert, Mr. Walsh.
Paragraph.
At A, on page 390. Never sought approval, render it invalid. As we understand it, Antigua law required stockholder approval. And then the skeleton argument for the claimant.
That's not based on purpose, is it? And that's just a statement that, and I think that accords with one of the grounds on which the rights agreement was challenged in the courts below.
Well, my lord, there are two aspects to that. One is, if it was a variation of rights, it required a special resolution. But the other is a common law. It's already been said, you can't do this without shareholder approval.
Yeah, and I think that was argued below, that point.
Well, that's what
But that, not based on improper purpose, but
it wasn't
simply you cannot do it without shareholder approval. Sorry?
Yes, you cannot do it.
Irrespective of purpose.
A common law, you cannot do it without shareholder approval. And then, well, my lord says irrespective of purpose, but if I may, that begs the question whether there ever can be a proper purpose, if I can put it that way.
But where is any pleading or evidence about improper purpose?
Well, my lord, the expression purpose is not used, but the reference to criterion as to why it's invalid at common law necessarily brings into play the reasons why criterion was decided as it was.
Yes, but whether that would flow through to another case depends on what you plead about the purpose in the other case, doesn't it?
Well, what is said is you simply can't do this. That's what's been said. You can't do this at common law, and that's what we want to run today.
But
in other words, there is no legitimate purpose that the directors can enter into.
well, I don't think, I mean, that isn't what is said in paragraph A. It's a constitutional issue. It simply cannot be done except with shareholder approval.
Yeah, I appreciate that, but this is simply the expert saying what he understands the position to be.
Yes, and as I understand it, as I said, I understood that particular submission to have been made in the courts below.
Yes, it was.
It was constitutionally impossible.
That certainly was made below.
That was made,
Yes.
yes.
And then we get to the the skeleton argument for the claimant below, which is at page 407, at paragraph 55, say the company has the burden of demonstrating the rights agreement is legally enforceable as a matter of Antiguan law, and the rights agreement was triggered in the circumstances of the AGM. So it's saying the company bears the burden of showing that this is enforceable as a matter of Antiguan law. And
can I be clear on that, that as I understand it, the appellant abandoned that in the Court of Appeal?
In the Court of Appeal. The burden point was, was abandoned in the Court of Appeal. And then over the page, legal enforceability dealt with shortly in 2 paragraphs. 58. First, a defensive shareholder rights plan of this kind is invalid absent shareholder consent. 28, see the third affidavit of Peng Fei Li. So in other words, going back to criteria. And secondly, it wasn't validly adopted as a matter of Antiguan law. So the invalidity absent shareholder consent point was set out in the skeleton argument. Then we see how the company understood this and dealt with this in the company's skeleton argument, which is at 418, paragraph 218. At 218, 1Globe's objections are that Antigua law applies English law, which doesn't allow defensive shareholder rights plans.
So just give me that page again, please.
Yes, 418, my lord.
Thank you.
And the objections are said to be misconceived. The Chief Justice Bermuda in Stainer expressly upheld the validity of a rights plan similar to the one being considered here. Rights plans are commonplace for companies incorporated in Caribbean jurisdictions. English common law does not prohibit rights plans. Rights agreement was validly adopted. So the question of whether English common law prohibits rights plans was dealt with in both skeleton arguments. Then what happens is that the judge decides, as he does in paragraphs 50 and 51, he says this is valid according to Stainer, because he says there's no breach of duty alleged against the directors. This wasn't a breach of duty by the directors. Now, he is picking up Stainer, and that Stainer, the purpose for which in Stainer the directors were said to have done this. But he's applying the Stainer test, which is the wrong test, which is you're looking at the question of breach of duty. Whereas Howard Smith makes clear breach of duty is not a necessary ingredient. So what happens at trial is that Stainer is applied, and what's happening here in this court is that we're saying Stainer was wrong. The judge was wrong to apply Stainer.
But was there any reference at all at trial to Howard Smith?
I don't believe so.
Yeah. I mean, the issue wasn't before the court.
Well, if I may put it this way, my lord, the argument wasn't before the court based on that Stainer was wrong. Stainer seemed to have been relied on by the judge, and it was not argued before the judge that Stainer was wrong. But that's an argument with respect. The point, the validity at common law was clearly before the court and was ruled on by the court. And then on appeal, the paragraph 70, page 439, is the skeleton argument at trial from the defendant, and you'll see how they put it.
Sorry, at trial, did you say? Or
Yes, at trial. This is skeleton argument at trial. Defendant skeleton argument 85 to 88, dealing with common law jurisdictions permitting shareholder rights plans. My learned friends say that this court would benefit from the consideration of the courts below. This is what they were arguing at the courts below. Caribbean and common law jurisdictions permit shareholder rights plans. There is authority, and they rely on Stainer expressly upholding. In
Can you just give me
Stainer,
the page number again? I'm so
yes, 439.
Thank you.
It was held it was valid as a matter of Bermuda law, including whether it was proper and constitutional exercise of the powers vested in such directors. Chief Justice held the distribution of rights in anticipation of a possible public hostile takeover was not unlawful, provided the directors had the requisite powers and they exercised those powers bona fide and fairly as between shareholders. Now, that's exactly the point we say that the learned judge in Stainer got wrong. In the present case, no allegation is pleaded of mala fides. And then, over the page at 440...
Well, all proper purpose. Well, a breach of fiduciary duty.
Yes. And then at 440, 811, in Criterion, the authority relied on by Mr. Lee, the question as to whether rights plans are permissible or impermissible was left open. Court of Appeal judgment makes clear there was in fact no dispute between the parties. It might, depending on the circumstances, be lawful for the company to enter into a rights plan. In fact, I think they're talking about poison pills in Criterion, not rights plans, citing Stainer and a Canadian decision, Tech. Proper purpose. It's a proper purpose case. That's what was being done. It wasn't argued below, as it might have been, but the point was there below. And then on appeal, at page 470, at 74, paragraph 74, this is where 1Globe accepted it bears the burden of proof. A trial had advanced its case on two different grounds. First, Antigua law does not allow defense of shareholder rights plans. No consent was given. Secondly, the requirements the Act engaged but not complied with. Fell into error in adopting and applying reason in Stainer and seeks to distinguish Stainer, but doesn't say that it was wrong. And in the Court of Appeal judgment, paragraph, which I have in the core bundle, Court of Appeal judgment at paragraphs 90 to 95, disputes the validity, doesn't allow defensive shareholder rights plans absent stockholder consent. 92, Stainer is referred to, not unlawful, provided that acts have the requisite powers under the company's bylaws. They exercise those powers bona fide. That is not for the purpose of entrenching existing management of the company. And fairly. Again, they do address the purpose issue, but the test is wrong.
So where do they address the purpose issue?
Well, they say not for the purpose of entrenching the existing management of the company.
Thank you.
And then at 97,
Thank you.
1Globe criticised the reliance on Stainer, and it sought to be distinguished. And then that is exactly the point on which we wish to appeal. Now, the fact that the courts were not taken to the authorities that might have assisted them is, we suggest, not a ground for saying that the point was not below, it's not before the courts, it was before the courts, it simply wasn't argued out before the courts. We say that those determinations of the judge and the Court of Appeal were wrong. We say Antigua and common law does not allow for rights plans. The point was dealt with below, We now wish to make sure that the court has the benefit, and the Delaware court has the benefit, of the correct determination on these points. Then we come to the question, so we then come to the question of the additional points for which permission hasn't been given. The first is the rights agreement point, and the second is the ground that the rights have been varied or added to. My learned friend objects to that on the basis that it's not arguable. The point with respect is...
This is the one taken in paragraph 23 of your written case.
Yes, that's right. The point that we wish to argue is that where the directors purport to give shareholders a right additional to those that they already hold, and they purport to do it by dividend in right of those shares, and those rights are inseparable from the shares, they have added to, not varied, or affected, as White and Bristol Aeroplane considered, they have added to the rights attaching to those shares. The bundle of rights is now bigger, and that's what we wish to argue, and with respect, that is an arguable point. The dividend point is also arguable. It was a point that was run by Mr. Sykes in Stainer. It is arguable because the question is, what is a dividend? My learned friend, in addressing you, referred to a distribution. We're not talking about a distribution. We're talking about a dividend and the meaning of the word dividend in the context of this legislation. And does a dividend have to be a share of the company's profits that is distributed to the shareholders in right of such? If it does, this doesn't fall under the meaning of the word dividend. And the answer that, well, never mind, the directors could have done it by some other means is neither here nor there. They didn't. If there had been other means, we would address them. The fact is they purported to declare a dividend. As Mr. Sykes in Stainer said, that actually doesn't work. And Stainer didn't deal with that point. All the judge did was say there is a power to declare dividends. He didn't address the point at all, Chief Justice, in Stainer. So the point is, with respect, arguable. It was arguable in Stainer, and it's arguable here. And it wasn't addressed properly in Stainer at all, having been raised and not addressed. And again, there are very good reasons, therefore, why this board should address the point.
Now this latter point, which is this one in paragraph 86?
Yes.
That's right. This was not argued below, or was this argued below?
This was not argued.
Not argued.
This was not argued.
So the first, paragraph 23 was argued, but this point was, or at any rate, not fully.
It was not separated out. I think one of the judgments refers to the fact that the power to do it by way of dividends, and I think relying on Stainer. So Stainer was relied on in respect of the constitutional power to do it. But again, the point wasn't specifically addressed below. But I would put it this way, it was wrapped up in reliance on Stainer to say this is what the directors can do. So again, we want to challenge that. It's highly arguable, and it's an important point. What is this? So, my Lords, I've just add some additional factors. Firstly, we say that the Notting Hill finance test and the Humphreys test are clearly satisfied here. There is no, these are points of law we wish to raise. There's no factual inquiry needed below. The fact that the defendants' witnesses weren't cross-examined on the question simply means that their statement of purpose below stands. They gave that evidence, and that evidence stands. And just as in Criterion, the matter can be dealt with, and as in Stainer, that purpose that is set out, and the judge said in Stainer, in fact, the same purpose here, as the judges below noted, was relied on. It's also can't be said that there is any other legitimate purpose, as the Vice Chancellor in Delaware said. It's not a question of independent management decision. This is a question of control.
As I understand it, your main point under the rights agreement is that it cannot be done under Antigua law, regardless of the subjective intention of the director.
Yes. That's absolutely right. And then
Isn't that the point that was argued?
yes,
Yes.
yes, it was.
Yes.
Yes.
So it's, as my lord says, it's not connected with purpose.
Well, only in the sense that there can be no proper purpose.
Right.
It's constitutionally, as a matter of common law, impermissible.
Right.
But I would just add some additional factors which may go to the question of discretion. The company hasn't pointed to any prejudice.
What's that point?
The company hasn't pointed to any prejudice. The company's, the finality issue doesn't apply because nothing's going to happen until the Delaware court has decided. So the question for this court is whether the Delaware court is going to have the benefit of the Privy Council's views on the law of Antigua, or whether it's going to have simply what is said below.
But if the agreement is invalid as a matter of Antigua law, the Delaware court will have nothing to do.
It won't. And the Delaware judge will
It's
be
not a
much
question of
relieved.
them having the benefit of our views. It will terminate the case as far as
It will,
Delaware
but
is
if it goes further, he will then have the benefit of the views.
Yes.
Either way, he will be greatly relieved, as you can see from what he said. Secondly, the company's own interests aren't actually engaged by this declaration. It doesn't impact on the company, it impacts upon shareholders, none of whom, other than the claimant, are before this court. So third-party rights are involved here. The company hasn't identified any corporate interest in maintaining the declaration. It doesn't even benefit from the operation of the rights agreement. If the rights agreement is effective, the company has the right to allot a huge proportion of its share capital for a nominal sum of money. That's the consequence. There's no benefit to the company. And the outcome, if the declaration is upheld, is a result that was, according to the company's written case, never intended. It was never the purpose of the rights agreement for this to happen.
No, it was intended to be a deterrent. That's
Intended to be a deterrent. It was never intended to happen. The company has no interest, they say, in having this trigger happen, but it has happened. So in this litigation, if the company is acting fairly as between shareholders, as it must, there are two groups of shareholders, one which will benefit hugely from a windfall and one which will have huge amounts of value taken away from them. And if one is looking ultimately in the interests of justice, then it must be right for the company to have the right answer in law and not allow procedural questions to get in the way. The company must want the answer to be the right one for the sake of all its shareholders. It cannot rely on a procedural bar to allow a windfall to happen to some shareholders, and for including the management consortium, it must be said, simply on the basis of how the case was managed by the company, by the lawyers below. It's not a basis on which the board should be entitled to entrench itself. It's not a basis on which the management consortium should be entitled to take control. And therefore, the interests of justice do, I suggest, require this tribunal to allow the point to go forward properly and not to be constrained by procedural questions in which the company has no, and certainly hasn't advanced, any interest of its own in putting up as barriers to the proper determination. On the question of discretion, just very briefly, the issue simply is this. if the court is considering the scope of the statutory provision in Antigua which allows the judge on determining a controversy to make orders, the scope of the orders that might be made on the determination of that controversy is one that ought to be bounded by the law and not by some abstract notion of the judge's views of right and wrong. And so the question that we want to raise there is whether the relief, and the manner in which the judge went about it, was giving that relief was within the scope of that ambit. It's important, it's an important issue, because the scope of a very wide discretionary power is a matter that is of general public importance. There isn't a previous case from Antigua on this, and the scope of that discretion is something that this court should again look at.
I'm not sure what you say the judge should have done if you lost on the underlying issues relevant to the AGM. Well,
the judge relied on Canadian authority where a shareholder had misled other shareholders. Yes. The judge in Canada didn't refuse relief to the shareholder. He granted relief. He granted another meeting.
But I'm not sure what relief you say you should have been granted if you were otherwise wrong on the AGM issues.
If we were otherwise wrong, then the judge should have considered granting a further meeting so that the views of those who he said had been, wrongly said, I must say, had been disenfranchised, namely those who weren't at the meeting, so that their views could have been heard. One might say that was the obvious outcome if you're trying to pursue shareholder democracy.
Did anyone contend for that in any of the courts below?
I'm not aware. I'm afraid I haven't.
Okay.
You can proceed on the basis they didn't.
I mean, the fact that an answer stares you in the face, Mr. Chivers, is one thing. I haven't seen that was an option suggested in any of the courts below.
I'm not aware that it was suggested in the courts below. Please proceed on the basis that it wasn't.
Getting a shaking head.
I have no reason to suppose that it was. Unless I can help you further.
Mr. Chivers, thank you very much. Mr. Potts, a brief reply.
My Lord, yes, very briefly. Firstly, on the Delaware point as to the Delaware, what the judge wanted or wants, page 3131, I think the Lordships were shown this. In fact, what the Delaware judge said was that findings have been made in Antigua and the time has come for him to move on to address the issue of trigger in that jurisdiction.
Page number?
That's page 3131 in the bundle, and also at 3132. So he has said he will be treating the trigger event as live, and he will move forward on that trigger issue.
I don't think we were told the date of this ruling. Does this come after trial and after the Court of Appeal?
Yes, it's 2019, I think. It is
after both.
Yes, after both.
And has he ruled?
No, it's there's of course. I think directions may have been given, but of course it's subject to.
I see.
This.
I see. Right.
It's stayed pending this, but
of course
he's going to move, and I think he's talking about an expedited trial for that trigger matter. So that's the first point. The second point on the defence, paragraph 14. All that was said there is the issue of was pointing out that the issue of trigger is a matter which is to be addressed in.
Page, just so we can follow.
It's paragraph 14 of our defence. I'm sorry.
Is it 334? Or is it 305? Maybe it's
305.
305.
And the third point. In relation to...
and I'm sorry, I was distracted by the reference. Your point on that was...
The point was that the matter was not put in issue in the proceedings in Antigua. It's a reference to the fact that the issue of trigger and questions around the trigger will be determined in the proceedings in Delaware. And my third and final point is in relation to the reference, the very sharp, small reference to criterion in that paragraph of an affidavit. We refer at paragraphs 8 and 9 to the oral submissions that were made at trial, and it is clear when one examines the transcript that in fact, the court was not taken to Criterion at all. In fact, the only point that was run, the single point, and it was made clear in the submissions to the judge, and the judge expressly queried and questioned counsel then appearing for 1Globe as to what their point on validity was. And it was made clear the point that was run was the variation of class rights, the section 161, 163. That, in fact, was the only point that was argued. And of course, as we say, if one looks at Criterion, it just doesn't stand in the House of Lords, which was the reference, it doesn't stand for the proposition which it is put forward for in that affidavit. But the point was just not taken forward at all in the order.
The reference in the transcript which you've just mentioned?
Yes.
What page?
We can find, in fact, there's two places I think we can find that.
Well, that's being sought. You said at paragraph 89, I take it you meant of your written case.
Sorry, it's 8 to 9. I'm so sorry, of our written case.
Oh, 8
Yes.
to 9.
Yes.
Sorry.
It's 8 and 9. So 8 and, sorry, made it even worse. 8 and 9
Of
our
written
written
case. Yes, okay. Thank you.
And there's a reference.
Paragraphs 8 and 9, just bear with me.
And
Page
1692.
1692.
Yes.
no. Yes. Yes, and there's also an earlier comment at page 1542 in the bundle, where again,
I think
yes,
the answer to my question is in, I think, the footnote, isn't it?
yes, it is. It's the footnote.
1615 and 1616, I suspect.
Yes.
Is it? Yes.
Yes, and there is one additional reference, which I'm just giving you, Lordship. It's 1542.
1542. Thank you.
My Lord, those are my points.
Thank you. The board is grateful to counsel for those submissions. We will adjourn now to consider those submissions and return in due course. The board is grateful to counsel for their submissions on the permission to appeal and recognises that the circumstances in which arguments were advanced below may have curtailed what is properly before the board now. The board reiterates the advice which it gave in Promeo on the principle of finality and the need to advance arguments fully at trial. And it also reiterates its reluctance to tackle new points of significance without the benefits of the national courts below. Therefore, the board has decided not to give permission to appeal on ground 1, except for ground C, D and H, which the board will hear de bene esse, and similarly the board will hear ground 3, discretion, de bene esse. Does council want a few minutes to adjust?
That might save time in the long run, if I may have a few minutes now. Thank
So,
you.
which 10 or 15 minutes to adjust, or
If we could have 15 minutes to
15 minutes? The board will then adjourn.
Thank you, my Lord. May we start with a run-through of some of the statutory provisions that we're going to be looking at? We can, of course, come back to them, but it's convenient, I think, to start off with an overview. The IBCA is at page 1747, which will be tab 1 of your authorities bundle. And we can start at page 1748 with share capital, 27.2, shares of personal property, 30, share issue, shares can be issued such time such persons as the directors may determine. 31, must not be issued till it's fully paid in money or property. At paragraph 35, the corporation may grant conversion privileges, options or rights to acquire shares of the corporation, but must set out the conditions of the conversion in any instruments issued as evidence of the privileges. Conversion privileges, options and rights to acquire securities may be made transferable or non-transferable, and options and rights to acquire securities may be made separable or inseparable from any securities to which they are attached. Paragraph 52 deals with dividends. The corporation may pay a dividend by issuing fully paid shares of the corporation and, subject to subsection 2, section 51, corporation may pay a dividend in money or property. Subsection 2, a corporation shall not pay a dividend out of unrealized profits. At section 60, page 1755, directors of the corporation must exercise the powers directly or indirectly through the employees and agents and direct the management of the business and affairs of the corporation. Paragraph 70.
Just thinking back to 52, it may help me understand a little more how this Act fits into Antigua and Company law generally. May not pay dividends out of unrealised profits. That implies somewhere or other that they can only pay dividends out of profits.
Out of realised profits?
Yeah, well, quite.
Yes.
But it assumes the existence of some restriction somewhere else that limits them to paying dividends out of profits.
That would be the common law restriction that you can't make distributions out of capital.
Right. Yeah. So there's no other statutory regime that helps on this, but it's built on a vast amount of common law.
Yes, and there is the prohibition in 51 in respect of a solvency test, which is overlaid on that.
Yeah.
Given that capital comes below unrealised profits, it's necessarily the case that you can't pay them out of capital. So all you're left with is realised profits.
Yep.
But I will come back to what a dividend is in any case and just discuss that a little. Then we have section 60, management. We then go on to section 70, which is about removals of directors. And the shareholders may, by ordinary resolution, remove any directors from office at a special meeting. And then 3, a vacancy created by the removed director may be filled at the meeting of the shareholders at which the director is removed, or if the vacancy is not so filled, it may be filled pursuant to section 72. Now, we're not dealing with a special meeting at which a director was removed. We'll come on to what we are dealing with, but it's just worth pointing that out before we move on to 71, which is the right of notice. A director of a corporation is entitled to receive notice of and to attend and be heard at every meeting of shareholders. And then 2, a director who resigns, who receives a notice or otherwise learns of a meeting of shareholders called for the purpose of removing him from office. Again, we're not actually in B. Or C, who receives a notice or otherwise learns of a meeting of directors or shareholders at which another person is to be appointed or elected to fill the office of director, whether because of his resignation or removal, or because his term of office has expired or is about to expire, may submit to the corporation a written statement giving the reasons for his resignation or the reasons why he opposes any proposed action or resolution. Corporation shall forthwith send a copy of the statement to the director and to every shareholder. And I think that's all we need from that section. Then we can go straight on to section 122, which is the section under which the application was made, that's before the court below and is before this court. Corporation or shareholder or director may apply to the court to determine any controversy with respect to an election or appointment of a director or auditor of the corporation. And then upon an application made under this section, the court may make any order it thinks fit, including without limiting the generality, an order restraining a director or auditor from acting, an order declaring the result of the disputed election or appointment. That obviously is what we're after. An order requiring a new election or appointment, and including in the order directions for the management of business and affairs until a new election is held, and an order determining the voting rights of shareholders and of persons claiming to own shares. Then go on to section 161 on page 1762, which is fundamental amendments to articles.
Sorry, page?
Following page
Oh,
one.
right.
So page 1762.
Yes, thank you.
Yes. Which is altering articles. And subject to 162 and 163, the articles of the corporation may, by special resolution, be amended. And then the things you can do, 161, 1C, to change the designation of all or any of its shares and add, change, or remove any rights, privileges, restrictions, and conditions, including rights to accrue dividends in respect of all or any of its shares, whether issued or unissued. And then
Is articles being used as a term of art? Because I noticed that in the constitution of this company, what we might call the memorandum is described as containing articles.
Yes.
What we might call the articles is described as containing bylaws.
that's right.
So it's being used as a term of art.
I think that's right.
Right.
The alteration at I is to authorize the directors to change the rights. And then at L, to add, change, or remove restrictions on the transfer of shares. And then you'll see at 163, there's a very similar series of provisions which require, on an alteration, a class vote. The holders of shares of a class are entitled to vote separately. And at C, you'll see to add, change, or remove the rights, privileges, restrictions, or conditions attached to the shares of that class, and in particular without limiting the generality of the foregoing. And then if you look at C4, to add, remove, or change prejudicially conversion privileges, options mentioned specifically, voting, transfer, or preemption rights. So to add options is within the generality, and it doesn't limit the generality, of the words in C. Of course, it's within the generality of the words of 63(1)(c), It's in the generality of the words at 61(1)(e) as well. So then we go to perhaps we could just go to a section that is not set out in this authority, although it was referred to by the judge, but he doesn't set it out in full in his judgment. We have set it out so far as relevant in our grounds of appeal, and it is attached to that appendix. It's at page 227. Where special business is dealt with, section 109. All business transacted at a special meeting of shareholders and all business transacted at an annual general meeting is special business, except C, the election of directors. 2, notice of a meeting of shareholders at which special business is to be transacted must state the nature of that business in sufficient detail to permit the shareholders to form a reasoned judgment thereon, and the text of any special resolution to be submitted to the meeting. And just moving ahead slightly, one will see that the then a judge below added an additional gloss as to what must be done in relation to notices or notice of intent for the content of a meeting. So, if there is special business, has to be in sufficient detail to permit the shareholders to form a reasoned judgment thereon. If it's not special business, i.e. the election of the directors, then no notice needs to be given of that business at all. That's under the Act. Then we move to...
Sorry, did you say that this was referred to in the High Court?
Yeah, the High Court refers to 109, but
Which paragraph was my question?
the judge doesn't quote all of that. That's
No.
why I've referred to it here.
But which paragraph? Sorry, the judgment. Thank you.
He deals with what is special business, but he doesn't go on to refer to the notice requirements at 109 subsection 2.
Yes, thank you.
Then the articles of association, the articles, I should say, of the company are at 551 of the bundle. And Article 3.3, sorry, 511. Maybe.
5?
So sorry, 511,
That's more like it, yeah.
the articles.
I was wondering.
Yes. And you'll see they're very short. Article 3, capital. Corporations authorized to issue bearer registered shares, designated common shares, and the preferred shares, designated preference shares, no preemptive rights. Both classes of shares may be issued in series, authority to fix the number of shares, determine the designation of, and the rights, privileges, restrictions, and conditions attaching to the shares of each series. Then 4, the powers of the corporation shall be exercised by the board of directors of the corporation, power to name officers, etc. And then if we look at the bylaws, placed at 515. In respect of share capital at 1.1, you'll see the power to issue shares is given there. The issue of allotment of shares shall be under the control of the board, which may issue the whole or any portion thereof, such referred, deferred, special or limited rights as it may think fit. And then 5, dividends. The board may from time to time declare the corporation may pay dividends on its outstanding shares in the manner and upon the terms and conditions provided by law. And then we have meetings. 7, we have the annual shareholders meeting. An annual shareholder 7.2, an annual shareholders meeting of the corporation shall be held every year after the incorporation at such time and such place, time to time prescribed by the board. The board may, when it thinks fit, convene a special shareholders meeting and shall do so on requisition. And then all business shall be deemed special that is transacted at a special shareholders meeting, and also that is transacted at an annual shareholders meeting, with the exception of the consideration of the accounts and auditor's report, if any, the election of directors, and the reappointment of any incumbent auditor. So that follows the statutory process, the statutory regime as well. And then at 7.11, which is on page 518, we have proxies at 7.10. Votes may be given either personally or by proxy. The instrument appointing a proxy shall be in writing under the hand of the appointor, etc. So you need a written form of proxy. Proxy need not be a shareholder. Must be deposited at the office or other place as specified for the purpose of the notes of meeting. Notes of meeting, written or printed notice stating the place, day and hour of the meeting, and in the case of a special meeting, the purpose or purposes for which the meeting is called shall be delivered not less than 21 days before the date of the meeting to each shareholder. At 8, number of directors. Less than until the corporation in general or special meeting shall otherwise determine, minimum number of directors shall be 1, maximum number shall be 15. Each director shall hold office unless removed as provided in these presents until the next annual shareholders meeting and until his successor shall have been elected.
So if there's an annual general meeting at which a successor is not elected, he stays in office?
Well, that appears to be the position, although if there was a resolution passed for his removal, presumably, then he would have been removed in accordance with the Act.
And that would override, you say, the last bit of 8.1?
Yes, I think that's intended to, I imagine that is intended to cover the position where his term of office comes to an end, but no one is put up by way of successor, which would be distinct from a resolution of the shareholders to remove him.
So, on the facts of this case, was if a resolution to re-elect a director is lost, it would look as if this article would apply. That wouldn't be a removal of a director, would it? Or would it?
That would. If he is put up for election and not elected.
Re-election?
Yes.
Right.
In other words, if there's no vote at all and the annual general meeting goes on, then he stays in office until the next annual general meeting and until his successor shall have been elected.
It's those last words.
Yes.
It's those last words.
I mean, what happens if, for example, a resolution to re-elect him is lost, but a resolution to elect a named successor is also lost, and there's only one director?
Well, we don't have to deal with that question.
Well,
I think.
Right. Yes. Okay.
There's more than one director, but
Yes.
I mean, one possible outcome of the AGM was that the re-election successful and the replacement wasn't successful.
Yes, it's always, of course, it's always possible that a company ends up with no directors.
Yeah.
It's not unknown.
Sorry. I mean, 8.1 seems, on the face of it, geared towards providing for continuity so that the company isn't left in that position.
It's certainly geared towards it, but of course if, let's say at a special general meeting, all the directors were removed, that would be it. They would be removed. The continuity doesn't apply, which suggests that where the shareholders have actually decided whether they want this person to be a director or not, there is no continuity. That would be consistent.
I wonder about that, because I mean, the principle in the last sentence of 8.1 is that someone remains in office until the next AGM or his successor has been elected, unless he has been removed. That does seem to be the clear reading of that provision.
Well, my lords, the question of whether a director remains in office would mean in those circumstances that no resolution need be passed for the re-election of directors. When the shareholders are going through the process of re-electing directors at the AGM, they're going through, unless someone else is put up against them, they're going through a sham process, because they can vote them down and find that they've still got the same director. So let's suppose there's a board of 5 as here, and the shareholders vote down 4 of them, and 1 is left. And they find they've ended up with the same 5 directors, if that's the interpretation of this provision, which seems, if I may say so, improbable.
Well, we have the words.
We have the words. We then look at 8.9, the powers of the board. Business of the corporation managed by the board, exercise all powers of the corporation required to be exercised by the corporation in an annual general meeting. As are not by the Act or by these bylaws.
I'm so sorry, where are you reading from?
So sorry, at page 520, 8.9, the powers of the board.
Thank you.
So they can exercise all the powers of the corporation as are not by the Act or these bylaws required to be exercised by the corporation annual general meeting, subject nevertheless to any regulation of these bylaws. Provisions of the Act, this may be prescribed by special resolution. And then at 8.11, removal of director, any director may be removed by majority vote of the directors, of the shareholders.
Yeah.
So it doesn't say at a special general meeting. If you have a majority vote, you remove the director. And then officers at 9.2, election and term of office. The officers of the corporation to be elected, I'm sorry, that's by the board. We needn't worry about officers. So those are the bylaws, and that takes us then to section 52
Of which act, sorry?
of the IBCA, which is in the authorities bundle at 1753. So this is the power to pay dividends. Now, this point about the power to pay dividends was raised in Stainer, and it's worth looking at that, which is at 2019.
So just as I'm clear, are you now developing the point of paragraph 83 of your...
Yes, I'm developing the dividend point.
Thank you.
The page 2019, at 20, and we have Stainer, which starts at 2004. And in this case,
You want us to go to 2004?
well, I think just so one sees that Mr. Sykes at 2005 was appearing for the plaintiffs. And
What a lineup.
2006, the issues that were being considered by way of preliminary issue are set out just under F. Following issues shall be determined at the preliminary issue whether the shareholder rights plan purportedly adopted by the Board of Directors and or the issued rights by way of dividend, purportedly by way of dividend, could as a matter of law be valid, constitute a proper and constitutional exercise of A, the fiduciary power to declare dividends vested in the directors, and any other power vested in such directors. And there's a lot about purchase of shares, which we're not concerned with. We start at 2019. At C, you see the contention in the amended statement of claim cannot be a proper and constitutional exercise of the power to declare dividends. Then we needn't be concerned with the power to grant options, which Mr. Sykes was arguing about, because a lot of this judgment was then taken up on the implied power of the directors to grant options. But here there's an express power of the directors, and so we're not concerned with that aspect of it. What we are concerned is the question of dividends, which is considered at 2020. Bylaw 34 gives the directors power to declare dividends. And you'll see that there's nothing unusual about bylaw in that form. But then bylaw 23 is referred to, the directors shall have full power in all things to administer the affairs of the company, consistent with the law of these islands. Mr. Sykes submitted that dividends have to be declared and paid out of the profits of the company. That undoubtedly the directors have power to do so under bylaw 34. But he submitted the poison pill involves no application of the profits of the first defendant, no distribution of any of its cash or assets, and therefore it was not a dividend. I agree with Mr. Sykes in this respect. If the directors have declared dividends under the poison pill, the court must be satisfied with the source of their power. And I would say the onus is on the defendants and directors to establish the power. Mr. Steinberg referred to bylaw 2, which states any share in the company may be issued, preference, etc. Having referred to bylaw 2, Mr. Steinberg submitted on his view to demonstrate the issue of shares is regarded as something within the powers of the directors. And then it goes on to a question of management powers, so page 221A. But we simply don't have any discussion by the judge of Mr. Sykes' point that this poison pill involves no application of the company's profits, therefore it can't be a dividend. So, learned judge relied purely on the power of the directors to declare dividends and the management powers of the directors. But he didn't address the question, was this capable of being a dividend?
You referred us to what Mr. Sykes' submission, page 2019, and there's a quotation there, but was there a further passage you referred us to? sort of spelling out what is very briefly summarised there.
At the 2019,
I'm just trying to follow exactly what the submission was.
yes, the submission is outlined in the statement of claim.
Yes, but it's a bit.
But then the submission, the bylaws are gone through. But the point about dividend was first raised expressly in 2020 in relation to the discussion on bylaw 34.
Yes, I see. Yes.
And then indeed, as the site submitted, that's the only place.
Yes, I see. The point. So, just to be clear for a moment, what was the poison pill in this case?
It was an almost equivalent rights plan.
So, I'm sorry, I
It
missed
was a
that.
materially equivalent rights plan
Which involved, therefore, an issue of a right,
by way of dividend.
and that right carried the right to an issue of shares in certain circumstances.
Yes, it carried a right to subscribe for shares in certain circumstances.
To subscribe. Right. At a very low price.
Yes. Yes, so everyone gets, it may be helpful to go to the rights plan just to see the mechanics of that.
Well, and yes, at some
But
stage.
broadly speaking, the rights plan gives every shareholder a right to subscribe for shares, to put it. And there are various possibilities, but essentially a right to subscribe for shares at a nominal value.
Right.
Which, when you do subscribe for those shares, will give you very valuable shares for nothing. But the right will be withdrawn from you if you act in a manner contrary to what the directors have set out in that rights plan. So if you make an agreement with another shareholder as to how you would vote, that triggers the rights plan. Every shareholder other than yourself and the other shareholder can exercise their rights at a nominal value. And you're then diluted.
Yes. So all shareholders. I mean, maybe. At some point, it would be helpful to see how the mechanics of the rights plan.
Yes, it may be helpful to do that. I say in terms of this point is raised because the rights plan starts off by dividending rights.
Yes.
To the shareholders.
So you have a dividend of rights, which are rights to subscribe at a very low price for new shares if certain events occur.
Yes, that's right. And those events are set by the directors in the rights plan.
Yes.
And they include buying shares in excess of 15%, to give you an aggregate holding in excess of 15%, or agreeing with another shareholder, or having an understanding with another shareholder how you will vote. And that will trigger the rights, which means that every shareholder other than you will be entitled to subscribe for shares.
But this point about the dividend doesn't really depend, does it, on that discriminatory effect? Are you taking a prior point that the issue of the rights cannot themselves be a dividend?
Yes, yes.
So it doesn't really, even if everyone could exercise the right in due course after a year, it would still, you say, be outside the director's powers under the articles.
That's right.
As you say, the right is what inherently in the nature of a dividend, but it's not within the power to declare.
No, it's not in the nature of a dividend.
You say the dividend has to come out of profit.
Yes.
You say the issue of the rights is not a payment of anything out of profits.
Yes.
That's the key point, I think.
That's it.
Yes,
exactly.
You can have, you've shown us the article which permits the directors to issue bonus shares, I think.
Yes.
But that's the distinction you're drawing. You're saying, well, the issue of the rights is not the issue of bonus shares.
It's not.
It clearly isn't. It's the issue of a right to subscribe for shares, albeit at a very low.
That's right. The statute provides how dividends can be paid, and they can be paid in fully paid shares, they can be paid in cash, or they can be paid in property. But first of all, you've got to decide what is the dividend you're paying, and that's what I hope to develop.
Yeah, I understand.
And at what point is the dividend declared? Is it when the rights plan is made or when it's put into effect later on?
When it's made, it's the first thing that happens. The rights plan starts off with, whereas the board of directors has authorised the company to enter into this agreement, authorised and declared a dividend. So before it's even written down, they have authorised and declared the dividend. It's the preliminary thing before the rights plan even gets underway.
Would that be a convenient place at which to adjourn?
Thank you, Bob.
Thank you very much.